Miami wrongful termination lawyer. If you were fired from your job in Miami, you may be questioning whether what happened was legal. Florida follows an at-will employment system, which allows employers to terminate employees for almost any reason or for no reason at all. Even under at-will employment, there are critical legal limits on why an employer can fire someone. An employer cannot terminate an employee for an illegal reason under Florida or federal law. Wrongful termination occurs when an employer fires an employee for a reason the law prohibits. Illegal reasons include discrimination, retaliation, breach of an employment contract, or violations of public policy. Florida law makes it unlawful to fire an employee because of race, gender, age, disability, religion, national origin, or pregnancy. Federal law provides the same protections through statutes such as Title VII, the ADEA, and the ADEA. If an employer fires you because you belong to one of these protected categories, the termination may be unlawful. Retaliation is another common basis for wrongful termination claims in Miami. Retaliation happens when an employer takes adverse action because an employee engaged in protected activity. Protected activities include reporting discrimination, filing complaints, participating in investigations, or requesting legally protected leave. If an employee is terminated shortly after engaging in protected activity, the timing may support an inference of retaliation. Florida law specifically prohibits retaliation under the Florida Civil Rights Act. Wrongful termination claims often rely on circumstantial evidence rather than direct admissions. Employers rarely state illegal motives, so patterns of conduct and timing are critical. Evidence may include emails, performance reviews, shifting explanations, or different treatment of similarly situated employees. Most wrongful termination cases are filed after administrative review by the EEOC or the Florida Commission on Human Relations. Discrimination claims must generally be filed within 300 days with the EEOC or 365 days with the FCHR. After receiving a right to sue letter, an employee has a limited window to file a lawsuit. Some claims, such as breach of contract, may be filed directly in court without administrative review. Florida employees are usually at will, but written employment contracts can limit termination rights. If a contract requires just cause or specific procedures, failure to follow those terms may be unlawful. Proving wrongful termination requires careful analysis of evidence and legal deadlines. The value of a wrongful termination claim depends on lost wages, benefits, and emotional harm. Damages may include back pay, front pay, lost benefits, and compensation for emotional distress. Each case is different, and outcomes depend on the facts and available evidence. Speaking with a lawyer early can help preserve evidence and protect filing deadlines. An experienced attorney can evaluate whether your termination falls within legal exceptions to at-will employment. BT Law Group, PLLC is a Miami-based law firm representing employees in wrongful termination matters. The firm is led by attorneys Jason D. Berkowitz and Annesley Tarragona. Both attorneys previously represented management and bring insight into how employers defend these cases. Their background allows this law firm to anticipate employer strategies and build strong claims. BT Law Group focuses exclusively on employment law and employee rights. If you believe your termination was illegal, speaking with a lawyer promptly is critical. BT Law Group, PLLC is located at 3050 Biscayne Boulevard, STE 205, Miami, Florida, 33137, United States, and you can call 305-507-8506.